Welcome to the second episode of 154 and the Fence. Today, we are honored to have with us Mr. Guneet Gudh, a distinguished principal associate in the investigations and white collar crimes practice at Panag and Babu. Mr. Guneet is a seasoned legal professional with a remarkable career that spans various aspects of criminal law, corporate compliances, and various aspects of white collar crimes like compliance advisory, due diligence, dawn raid assistance, internal investigations. He has successfully represented clients in high stakes criminal matters before courts, offering his legal expertise in some of the most complex cases. His expertise also extends to guiding clients through intricate investigations conducted by law enforcement agencies. He has also provided comprehensive anti bribery and anti corruption training to corporate houses, helping organizations navigate the challenging landscape of regulatory requirements and ethical practices. We are truly privileged to have Mr. Guneet with us today to share his insights and experience. His deep knowledge of white collar crimes combined with his practical approach to legal challenges promises to make this highly informative and engaging episode. So before we dive deeper into the technical aspects of PMLA, I did love to hear about your personal journey. Like what inspired you to pursue a career in white collar crime law?
Sure. Thank you, Prakhar. I think that was a very kind introduction, and I don't know if I deserve that, but thank you so much. And it's a pleasure to join you, and I hope that I do justice to the knowledge sharing session which we have planned to do. Prakhar, to answer your question about what shaped my journey to come into this practice. To give you some insight about my background, I come from a business family and a hardcore business family, which is an experience of more than 60 to 70 years, generations of into business. And both my parents are serial entrepreneurs. My mother has her own ventures, my father has her own ventures. So I have grew up in a kind of an environment where always from a very early age, I could see the chatter about the conversations about the business issues, legal issues. So I caught them up very early. But yes, when I was very young, I was not sure if I want to be a lawyer. But I think by the time I finished my journey in the school, and I come from a science background. So very few lawyers you'll find who come from a science background. But uh, as soon as I was ending towards my journey in the school time, I was sure that yes, I want to do something in law. But I think my relation from with my parents and knowing about so much about business at the early age, I was sure that I want to do something pertaining to helping the institutions, corporations to function better and to also how to manage day-to-day crisis situations. So that was one early kind of experience which I had. But after I graduated, then I moved to Bangalore and joined a firm called More Global, where I did hardcore forensic work. And after doing that, I was, I think, very close in understanding what exactly happens in the forensic investigation practice. And I think I saw it very personally, what to look for in the documents, what to not look for. And I think at that point of time, I also got a great experience of working with major big corporates. One was British Petroleum. I think that really helped me, and I was very sure okay, this is what I wanted to. But after that, I wanted to do some hyper specialist work, and in that point, at that point of time, Panag and Babu was the only space which was doing this kind of work, and I was very lucky to have Shirmi Panag as my mentor, and I think the rest has been history. It has been more than 6 years now that I've been with the team of Panag and Babu, and had a pleasure of working on one of the most prominent matters in the country. So, in brief, that is what my history and life looks like.
Okay, so now to start with our discussion, significant developments in recent years have emerged in the anti-bribery and anti-corruption space. Now, with increasing regulatory oversight and evolving business practices shaping the landscape, as an expert on financial crimes with experience representing of major corporation, could you share your insights on some of the most pressing legal trends or challenges businesses face today, particularly in light of recent legislative changes.
Yeah. So, Rakha, I think we have seen a tremendous change in how things have shaped up. But one constant issue with the businesses always remain is bribery, corruption, and fraud. This is nothing new. This has been happening from decades, and I think this is going to happen. And this is the real fight where all the corporations are fighting for. Yes, the laws change. There are some developments in the legal industry, but the basic principle remains same globally. The recent trends have been seen when you see there is a change in the way the businesses function. Earlier, in 90s, you would have seen usual businesses happening. A lot of things were not digitalized. Okay, at that point of time, there were other means of doing the business and doing the other business, which is called like engaging into bribery, corruption, etc. Those were time consuming to be traced, but however, in the 2000s, as the digitalization has stepped in, you will see a lot of trends moving on to the digital platforms. And I have a experience of working with a lot of startups in the PE firms also, and I've seen the main pain point becomes again how to manage the funds, and usually how to stop the leakages into that direction. So I think that is one trend which we are seeing. The other trend, I think, what digitalization has made it easy for the enforcement agencies and also for the experts like us is to catch such issues. I won't say that you can catch everything at the very first instance, but yes, there always mean the transparency can be increased. There are more ways to become more transparent and also to analyze and assess the situation. So I think having a good, strong compliance structure, which is like more of about sealing the areas where you think there could be leakages, such as finance departments or the departments where you think procurement of the business, there are high chances that you can avoid such scenarios, which were more difficult to be avoided when the businesses were run in a very general way or when the traditional practices were prevalent of hard copy documentation to be recorded and approvals to be taken from the department by going to the offices of the government officers, standing in the queue, waiting for them. Now everything is digitalized. You can send documentation requests through emails. You can apply for licenses through emails. So that somehow has reduced the chances of bribery, corruption, and fraud. And again, the digital payment structure is again a big benefit for the corporates to ensure that there is more transparency in this area.
Okay, so that was very comprehensive. Now, moving ahead, now let's go into PMLA as of now. So, PMLA is often in the headlines not just because of the high-profile cases it's involved in, but also due to the immense power it grants to the enforcement directorate. But what really lies behind this power? How does the law operate, and what does it mean for the rights of the individuals caught in this system? Now, in today's episode, we are going to discuss all these questions and set aside the political debates surrounding ED and focus purely on the legal dimensions of Prevention of Money Laundering Act. Now, the core of a conversation will revolve around the statements and objects of PMLA, the issue with the ECIR, and the communication of grounds of arrest under the PMLA. Now, these elements have been pivotal not just in the enforcement of the law, but also in shaping the legal discourse around the personal liberty and state power. We'll understand how these provisions operate, their legal justification, and the controversies that they have spawned. Now, to start with the things, could you first explain what money laundering actually is and how does it operate within the broader financial system?
Sure. So I think money laundering as a concept is very simple. Money laundering is basically the steps you take to conceal the origins of any money which is generated by illegal means. Could be by selling drugs, could be by selling any kind of land which is not your property. So that is how that's basically the process. You're trying to conceal the origin and then trying to bring that money into the financial system, which is the mainstream system, and ending up using that money for your day to day expenses or bringing it into the business, buying a house, doing a wedding or anything, whichever is legal. So this is main concept of money laundering. Now, as you have mentioned about PML, yes, PML is a law which is specifically designed to ensure that we can avoid any kind of money laundering. That's why it's called Prevention of Money Laundering Act 2002, and we refer to it as PML. Now, what are the basic, I think, principles of PMLA? What PMLA covers, or what is Section 3 talks about? Again, money laundering. Then the Act gives power to Enforcement Directorate, to which we refer to as ED, as a specific agency which looks into all the specifics, or all the which is the main authority which looks into all the acts of money laundering, and make sure that like things are into system, if I can say that. And then the powers are given definitely to ED, such as attachment of property, which by law allows the provision of attachment, and ED can is empowered to do that. Then we have investigating and enforcement is again ED's under ED scope. ED investigates the matter, and then there's a whole process which starts, and the process again, like starts with summoning, and the people are summoned. So that is how the whole structure is developed in the country. Now, talking about the scope, um, I think we need to take a few steps back, and I think originally the original mandate by which, or the idea by which the PMLA was brought in, was to counter serious offenses. And at that point of time, serious offenses were mainly uh, the business of drugs, etc. But again, the scope has again widened up, and now you have charges such as of corruption, tax evasion, etc., being brought into the ambit of PMLA. Now, where the problem comes, according to me, Brakhar, is that the original intention was perfectly fine. We need to go for hardcore criminals, hardcore offenses. Yes, bang on. We have PMLA, we have enforcement directorate. The issue became when small matters such as corruption and tax evasion were also brought in. Then there is a question that, are you diluting the powers? What is the police going to do? What is the tax department going to do? What is the vigilance office going to do? If everything has to be done by ED, then what is the purpose of having these other departments? And when this starts, and when the trend starts establishing about one specific kind of corruption cases we are seeing, of high profile politicians being arrested, that raises fair questions, and that raises fair questions on credibility of the department itself and the law. But again, I think what is important to be understood here is that my problem would not be with regard to who is being arrested, who is not being arrested. But my problem, I think, my main concern is that the delusion of power is real. Prior to 2018 amendment, things were bifurcated: what are serious offences and what are not. At that point of time, getting a bail was also easier. But with the judgment, with the very famous judgment of Vijay Madan Lal, I think things got, yes, the intention of the Supreme Court was very clear with that judgment, but I think then that creates more concerns for an individual. And as lawyers itself, because we have seen the trends of getting bail, and I, from personally from my experience, I could tell you that we have so many clients who raise very fair questions about a transaction which they would have done, or any kind of concerns. The bigger problem is that the investigation starts, the bank accounts get frozen, the whole business gets hampered. So something needs to be done into that procedural front, and how the matters to be investigated, what is serious, what is not serious, in what cases you need to freeze the account, in what cases you need to arrest the person. So that bifurcation is very important.
Got it. Now, so one of the most controversial aspects of PMLA, is its broad scope. And over time, the law has come to include wide array of offences in its schedule, many of which go beyond its original intent of combating the money laundering of drug money. Now, what's your take on this expansion, which has sparked significant debate about the law's reach and its impact on the individual rights?
Yeah. So exactly as I said, Prakhar, it has definitely broadened, and My problem again is with the expanding the scope. Like I would say, yes, if you want to expand the scope, there should be some threshold on the quantum of fraud or the quantum of money involved in it. I would be fine with that. But even a small matter of corruption, which is of 100 rupees, can be investigated by ED, and the person can be arrested or and kept into in custody prior to even the procedure, prior to even the investigation is started for a year or two, or while the ED is investigating. I don't think that is fair. So I think that is something which the courts need to relook, and that is the main pain point and the concern for all the people who are again dealing with PMLA and are being investigated by ED.
So now, could you explain how an individual typically comes into contact with the PMLA? Like, what are the common scenarios or triggers that lead someone to be investigated under this law? I would like you to focus on the initial steps involved from the moment suspicion arises to when the ED starts its formal investigation.
Yeah. So uh, the step is very simple, to be honest, and I think in today's world it's more streamlined. But it all starts with any kind of suspicion when any department has. Now, usually, what we have seen very commonly is that suspicion transaction report it's called STR, which financial institutions are mandated to create and generate. Now, these reports are generated by different banks. RBI has collective data of this, but the banks can also provide it to the enforcement directorate if required. Then all of these STRs are again at the end submitted to Financial Intelligence Unit of Government of India, from where anything which is looked into as a red flag is being flagged and given to ED. So that is one. Second way is that any institution such as bank or any other entity, if they see any kind of transaction which they seem to be odd, for example, small transaction of 50 rupees coming in like 50,000 times into one account, that raises suspicion that from what is the source and similarity, or anything which is like out of order, one account has been inactive for a very long period and suddenly there is a transaction of 10 cr 15 cr into that, so that is again a suspicion. So these transactions get flagged. Now, what has again changed the environment is, Prakhar, is the synergy which has been created with digitalization amongst the different departments. The bank's data is directly related with RBI. Now, RBI submits its reports to the government of India. The CBI gets information, and the ED has information. The vigilance officer has information. So this synergy has also made it easy to notice any kind of unusual transaction into anywhere into bank accounts or anywhere else. And fair questions are raised. There's so many times when even an individual's account might be frozen for a few hours if there is multiple transactions done into that account. So this is the usual practice. Thirdly is how whistleblower complaints happen. So any person who has any information can raise a complaint. ED has a process for that. You can raise it through their website, or you can submit your complaint in writing to them. There is a debate about if the whistleblower protection is provided or not, and most of the time it's not disclosed because as you know, ED has a kind of reputation of not disclosing a lot of things. So definitely, this is important not to be disclosed. And any of the cross-border transactions which are done, again, there's a separate data which is being generated for this. What has come into the country, what has gone out, and even if you would have tried sometimes to transfer money abroad, there's a proper banks have a very detailed process of writing what is the purpose, is the how were the funds generated by a person who's sending it abroad, whom you're sending it to, family, relative, friend, what is the purpose. So these transactions get mapped very easily, and any of the transaction which they think is out of order, the questions can be raised. And the next step is that you will call upon for a clarification if there's anything which ED wants to know.
Okay. So moving ahead, the discussion on PMLA cannot start without deliberations on the judgment of the Supreme Court and Vijay Madanlal Chaudhary. Now,
Yeah,
in this case, the Supreme Court delivered a long pending verdict on the constitutionality and interpretation of various sections of PMLA. Now, the court, while upholding the constitutionality of PMLA, also decided on large number of crucial issues relating to personal liberty, the scope of arrest, bail, remand, and grounds of arrest. However, the issues addressed in this judgment are by no means settled questions and are likely to see continuing judicial engagement. Given that this judgment, Vijay Madan Lal judgment, has been challenged through a review petition, what are the specific issues associated with it that have sparked such opposition?
sure. So I think, yes, as you said, it's like if you're talking about PMLA, you have to talk about Vijay Mandalal's judgment. So I'll take a few steps back and I'll try to explain a timeline of how things happen. So 2002 enactment of PMLA happens and the law is brought in. The problem starts in 2018 when expansion of the PMLA scope is done. Various amendments are introduced to broaden the scope of the PMLA, expanding the list of predicate offences and under its schedule. This is done. Then the whole cycle of filing petitions is done in 2021, where multiple petitions were filed in Supreme Court challenging the amendment. And at that point of time, we have the Vijay Madanal Chaudhary's matter being the whole proceeding starts from that point of time. So, what were the key points which were raised in Vijay Madanal Chaudhary's matter was first of all constitutionality of arrest of power. Now, issue is petitioner challenged the PMLA provisions that allowed enforcement directorate to arrest individual without providing them with a copy of ECIR, which is Enforcement Case Information Report, very similar to FIR, but I think we're going to discuss that later in this session. So I will leave it for a later stage. So that was challenged. Now, what is the process? The process is that under Section 50 of PMLA, a person is summoned. But even if you, I'll tell you from my experience, if you see the summon, Prakhar, the summon has nothing written on why you're called by enforcement directorate. It's just that under Section 50 of PMLA, you're requested to appear, and if you violate this, etc., proceedings will be taken against you. And sometimes there is an extra attached to this which says, okay, when uh, you come and meet us or anything like that, there is a list of documents, usually mostly financial related documents such as bank statements of the individual or the company, and those are requested to be produced. So the core problem is that the person is not aware of for what reason he is being arrested. Till the time you don't have the copy of ECIR, you don't know why you are arrested. I'll expand on this later, but this was one of the major contentions. Second comes is the presumption of guilt in bail provision. Now, Section 45, before that, as I was explaining you, there was a segregation. But after 2018 amendment, the segregation was removed. Now, the problem is that under Section 45, the twin condition was imposed. And under the twin condition, the person had to, first, the public prosecutor has to give him the chance to oppose the bail. And the court should have to be made, the court had to be very much in surety about that the person is not involved in the matter what is being investigated. So this is again very like out of order. Like how can uh, how can you assure the court before the investigation has even started, or if the investigation is happening, the person is not involved into the crime for which he has been arrested or something? And another thing, the problem is that most of the time, an individual, when he appears in front of ED, he's not even sure if he's a witness or he's an accused because no information is provided to him. He or she is not aware about what wrong they have done, and then you are called, and then you asked for information. And another big problem which comes out to be is the admissibility of the statements which you give to uh, the enforcement agency. Anything which you say can be admissible, and again, there is no structure about all the statement has to be provided to the court, or a selective portion can be provided. There's so many matters in which we have seen that statements are recorded by the agency, and but not all the statement is submitted to the court. So the bigger problem comes out to be is that even the court even the court is not very much clear, or the procedure is so not transparent that even the court is not aware about what's happening behind, or what the agency is doing. So that is a very broad scope of powers to be given to any kind of enforcement agency, which is formed in the Constitution of India, but it's not fair to the person or the accused that the ambit gets so wide. Then I would again, the other issue is definitely attachment of property, but again there is a counter statement could be that most of the cases we have seen when it's not under PMLA, that the people who are accused of corruption or any kind of money laundering, basically they try to dispose of the properties, which is a genuine concern by the court and the enforcement agencies, because we have seen such cases. The properties get disposed while the investigations are going on, and then there is nothing to recover. So that is something, but I think again that has to be segregated, as I mentioned before, on the kind of like serious offense it is. I'm fine if the offense is very serious. Yes, the attachment property should happen, but in small matters, I don't think that's the fair way of the fair process, because most of the times it hampers the businesses. Sometimes business units get attached, houses get attached. So I think till the time investigation has not completed, that should that should be avoided. And again, I think admissibility I already spoke. So these are the main pain points which I see with regard to Vijay Madala Chaudhary's judgment. And uh, let's see. It's requested to be reviewed, but how the review has been deferred for now. So we'll wait to see what happens. But yeah, this is pretty much what I have to say on Vijay Madala.
Okay, so now let's talk about section 45 of the PMLA, which is I mean, this section has been in news lately. So this particular section, it is stringent when it comes to bail. It starts by making it clear that bail is generally not an option when it comes to offenses under this law. Now, this sets a high bar for the accused. The This provision makes it mandatory to hear the public prosecutor in all bail applications, and when the prosecutor opposes the bail, the court is required to apply two conditions. Firstly, that
Yes,
there are reasonable grounds for believing that the accused is not guilty of such offense, and secondly,
exactly.
that he is not likely to commit any offense while on bail. Now,
Yeah,
if you could shed light on what the issue is with the twin bail condition and why it contradicts the criminal law jurisprudence and how it impacts the criminal justice system.
yeah, yeah. So, Prakhar, as rightly mentioned by you, and as we touched briefly about this, Section 45 of the PMLA lays down two conditions.
Hmm.
One is the public prosecutor is given opportunity to oppose the bail application which is filed. The second is the court is satisfied that the accused is not guilty of the offense and is unlikely to commit any offense while on bail. The
Yeah,
second part is very fair, which is like general trend and practice and general legal jurisprudence, which has been followed throughout in any bail application, that the person is not going to tamper, not travel without permission, blah blah. But the whole parameter of not guilty of the offense, this is problematic, because while the investigation is happening, and to assure it to the court that the person is not guilty is very difficult. Now I'll give you an example. X person gets arrested. Investigation takes time. You have so many witnesses. You have a huge chunk of documentation to be looked into. Till the time that is not done, how is it possible that even the public prosecutor can assure, or like can give any statement, or am as a lawyer of a person can say that the person is not guilty of the offense, and how I can make the court satisfy on that? That is the main problem. So there's so much of gap between this understanding that it has to be really understood that this requirement is very difficult to be fulfilled. Now we have seen the changes happening recently, as into the latest judgments, which I think again we'll touch upon later. But again, now we are seeing that kind of shift which is happening. But I think again, what is important to be looked into this is that prior to 2018, as I mentioned, amendment, predicate offences were classified into two categories, wherein there was a bifurcation of those offences which had minimum of 3 years of imprisonment and other offences, which were like more into the serious category. And the twin condition were initially only mandated for more serious offences as compared to the other ones. Then, in the case of Nikesh Tarachand, the Supreme Court of India held that the bifurcation to be invalid and declared it to be unconstitutional. So then this issue was cleared, and then there was no requirement of twin bail condition. Then it was simple, like how it happens in other matters. But again, Parliament later decided this classification and was important, and then they brought in again the two classification and the twin bail requirements under Section 45. Then again, you know what happened with Madan Lal, as we discussed. So this is the brief history of how things transpired and where we are. This is the journey, basically, what we have traveled from Nigesh Tarachan to Vijay Madan Lal, and now what you're seeing, the recent trend of like all these political matters, starting from Mr. Manish Sisodia to Prem Prakash's.
So, like recently on August 28th, 2024, the court reaffirmed that bail should be the rule and jail be the exception, even in the money laundering cases. They emphasized that personal liberty is the fundamental principle. So, my question is, does this principle potentially contradict the legislative intent of the PMLA Act, which tends to impose stricter conditions on bail?
Yeah. So I think again, Prakhar, see the issue with the twin condition requirement is again that the presumption of guilt versus presumption of innocence. And as a legal jurisprudence always says, the presumption of innocence is always what we should be going to the direction of. But like again, the PMLA changes the whole paradigm, and
Hmm.
we are looking to the person as guilty, and an offender. So that is again very problematic. And if the law is such, then to be honest, even the courts can't do anything. So that is where the problem stems from. Second problem comes on to the burden of proof on the accused, which is again, as we discussed, one of the conditions into the 12 bail. Then you have denial of bail in non-serious cases. By non-serious cases, I mean I deem to refer to the cases which are like of smaller scale as compared to money generated from drug money, etc. And in these cases, the problem is that the broader scope of the PMLA allows for wide range of offences to be brought under its purview. And in some of the cases, like the right to bail, which we always voice on as the legal community, that get evaded. So that becomes the problem. Now, what has happened in the recent judgments, and not only talking about the Prem Prakash, but I'll talk about the three prominent judgments which have come in last 1.5 months. Starting from the Manish Sisodia versus CBI, I think in this the court again mentioned, and if you see the common theme which we are seeing from all three judgments, K. Kavita, Manish Sisodia, and Prem Prakash, is the time the investigation authority is taking to investigate the matter and the multiple filing of charge sheet. That is the problem which the court has caught upon, and that is the benefit which the court is giving to the accused. That till the time the investigation is happening, it's not fair that you keep the accused in custody for so long. For example, in the Prem Prakash judgment, the basic the basic principle on which the court has relied on is that ED has huge number of witnesses to be investigated for now and to record the statement. So the court has said that bail again is the rule, and jail is the exception. So that should be followed, and they have brought it back into the whole PMLA kind of like a judgment, which was missing from very long point of time, and we were not listening to these kind of judgments coming out from Supreme Court or High Courts. And the court also observed in this Prem Prakash judgment very clearly that the appellant has already been in custody for over a year, and the trial is yet to commence. So this, you see, like the problem is the trial has not started. Only the investigation is happening. The enforcement agency is collecting evidence against you, but you are in jail. And after recording all the statements, providing all the documents, information, what the enforcement agencies need, but you are held in a lockup. So that, I'm glad that the courts have looked upon that critical problem, and now we are seeing the results of it. But I think it's very important that all the matters are analyzed with this lens, and we are fine if it's looked case by case to base cases. But I think it's very important that before trial, it should not happen that the accused are in jails for more than a year or two, because even if the punishment is for 3 years or 4 years, they spend half of their jail time already before the trials have started.
Got it. So, like, while Section 45 creates significant hurdles for those seeking bail, the ECIR adds another layer of complexity to the rights of the accused, as the ED is not obliged to provide the copy of ECIR. Now, the Supreme Court has already justified this stance by stating that ECIR is not the same as FIR, and therefore it will not fall under the mandatory disclosure requirements outlined in the CRPC. Now, this has significant implications for the transparency and fairness of the legal process. So, understanding the role and nature of the ECIR is crucial in this context. Now, could you
Yeah.
start by explaining what exactly the ECIR is and how it functions within the framework of PMLA?
Yeah. So again, ECIR is called as Enforcement Case Information Report, and then you have FIR, which is like which is like First Information Report. I would say similarity. Again, both of the reports have very similar content. What basically the crime is, who has conducted the crime, under what sections of the law of the statute the person is being charged on, and exactly what the matter of the fact is.
Hmm.
Now, when it comes to ECIR, ECIR is considered as an internal document of enforcement act. However, FIR is not. That is the biggest difference which comes out to. We have seen some cases way back where in some of the matters the court has given the permission to the accused to look into ECI once the trial has started or before the trial. But now that is all history, and that we have not seen happening in a very long period of time. Now, the main problem which comes with this is that that enforcement directorate will initiate PMLA investigation against you. Now, a person gets a summon, and the person says, "Okay, you have to appear in front of the enforcement agency." The whole problem, again, as I mentioned before, is that you don't know even if you are accused or a witness. On what basis you are going to file for bail? Till the time you don't know what you have actually conducted, what your crime is. And that's why the twin condition, which is put under Section 45 of the PMLA, becomes so difficult to be fulfilled. Because when you don't know exactly what you have done, how you are going to fulfill the condition? If I know what I have committed as a crime, I can take that document to the court. I can build up my story and narrative what exactly has happened, and it is not what with the lens with which the enforcement agency is seeing the whole matter. But again, this is very different in a PMLA investigation, because till the time you don't have ECIR and you don't even get the copy of the ECIR, so you are not aware about exactly what has happened, and that becomes very problematic. And I think personally, this is something which I really want to change, and I find it to be a clear violation of Article 20 of the Constitution.
So just a follow-up question, as you said that earlier courts were in favor of disclosing the ECIR, but the trend is not to be seen in recent times. So why do you think that the courts are, changing their stance?
See, I think, Prakar, the problem is pertaining to how the enforcement agencies looked at. Courts have mentioned that ED is not as police. So they have made a very clear distinction with this. Once that distinction happens, all the requirements don't fall onto what falls onto a police. For example, CBI has a CBI manual which is available. ED manual is again considered as a private document and not a public document, so you don't even know how ED functions. uh, but then, with regard to, if you see under IPC, you have section 160 where accused or witness is cleared, and the FIR has that written for what basis you are called upon. Again, here there is a complete. You don't even know about exactly what you have committed. So I think the problem is the basic. There is no, like, obviously the distinction is this only, that one agency is not seen as police. One agency is seen with a very different lens as compared to all the other agencies in on one side.
Okay. So as pointed out earlier, how does the non-disclosure of ECIR to the accused impact their rights, particularly in terms of preparing a defense or challenging the grounds for their investigation or arrest for the purposes of bail?
Exactly as I said, Prakar, you are not aware about what you have done. You are
Hmm.
just thinking about what could be the possible problem which would have committed. You rely on, when you're called upon to ask for statements, when you're summoned by ED, then you try to uh, see what could have happened, and with the kind of the narrative of the questions which are being asked to you, and you think, okay, this would be the crime which I've committed, and you tell your lawyers, and then the lawyers prepare the defense. But I'll tell you what we as professionals do in most of such cases. We do assess the kind of information ED has requested, and we try to connect dots. We conduct quick, comprehensive internal checks for our clients to ensure that we are able to crack the code and see, okay, what could be the main pain points for the clients, what could be investigated, and we prepare a defense on those grounds. And the defense is usually prepared to ensure that, first of all, you do a house check. You get all your documents and records in order, board meeting records, any of the records which are usually created as in the normal course of business are properly documented. And I think the best way uh, to ensure that you have the strongest defense is always to cooperate with enforcement agencies, and always to respond to any information requests which are being required. And I think corporation becomes a big defense in any of such investigations. And I think that also sets a record straight, because once you don't comply with the requirement or the order or the summon, it just then everything, whatever the everything is downfall after that. So I think that is the basic principle what we use, if I have to tell you from what we do in our general practice. uh, so that's pretty much to answer your question. I hope I have clarified that.
Yes. So just a follow-up question here. RK Arora judgment, which came last year, it mandated that the ground of arrest needs to be supplied to the accused. So do you think that that problem, the non-disclosure of the ECIR, that problem which emerged after Vijay Madan Lal, that has been diluted uh, under this judgment of RK Arora? Like now the
But again,
accused is aware of the grounds of arrest, so that may help him in preparing the defense for arrest.
this is done orally. So the whole problem is that, like, orally you might get to know what is the reason why you're arresting, but who is going to check what was told to the accused at that point of time? And was the officer on that day who was arresting the accused, or like what are the grounds of investigation? Was it clearly informed to the person or not? And there is no going back to that. I can't. No one is accountable. If there was a video recording happening, perfectly fine, but that is also not the case. So this makes a big difference, and I don't think that is of any use. What could be beneficial is something like that, like a written document could have been provided. That is very helpful, but till now we have not seen that.
So, do you think that if ECIR is made a statutory document, it would be given the pedestal akin to the FIR, and then just like how the person is well within its right to go through the grounds mentioned against him in the FIR, the same can also be done for ECIR.
I think it is very important that it gets into the category of a statutory document, because then the whole transparency and again the questions raised against the enforcement agencies are also cleared. Because at one point, yes, we definitely have a lot of problems with the law, but again, that problem should not come to the agency. Now, everyone looks to any PMLA matter, and enforcement agency ED is also looked at it with a similar lens that okay, this is not a very transparent investigative agency. You don't know what they'll do. You don't know on what account they're going to arrest you. You don't know what kind of statement they're going to use against you, and the statements are admissible. So I think it's the requirement of the time that ECIR becomes a statutory document, and it's looked exactly similar to how, with the same lens, how an FIR is looked, and it's publicly made available. Some of the information can be redacted, which enforcement agencies think, but I think the grounds on which a person is arrested, what his crime is, I think that is very important to be informed, because I think that is a fundamental right of any person.
So moving ahead, I'll now discuss how Section 19 of the PMLA comes into picture. Now, according to this section, the investigating officer must have, based on the material in their possession, the reason to believe that a person is guilty of an offense punishable under this act. Now, this belief must be documented in writing. Once this is done, the ED has the authority to arrest the individual. Now, it's crucial to understand what essentially Section 19 is trying to say is that ED must have sufficient material to justify an arrest before taking any action. Now, this implies that grounds for arrest are well established even before the individual is detained. Now, this raises the question, why not provide the arrested individual with these grounds in writing immediately at the time of arrest? Why do we have judgments like R.K. Arora by the Supreme Court where it was held that ED is under the obligation to provide the copy of written grounds of arrest within 24 hours? What are the implications? So, my question to you is, what are the implications of only orally communicating the grounds of arrest, and how does this affect the transparency and fairness of the legal process?
It's exactly, see, like when we talk about the principle of fair trial, this also falls into a very similar category through my lens. I think if a fair trial has to happen, the person definitely should know exactly what crime he or she has committed, and why he's being considered as accused. Now, coming to the point that under Section 19, there's a requirement that ED only will arrest a person when they have sufficient grounds. But Prakha, the problem is how these sufficient grounds are read by an enforcement agency is very different. How it is going to be read by the judges, and how it's going to be read by the accused himself. There's always a background story to each action which has happened. One transaction happening coming into my account, I might be the better person to explain what exactly has happened rather than other person sitting in the office of an enforcement authority and reading it with a very different lens. So I think that is again, I think very debatable, because it's always fair. Enforcement agencies can say that yes, without conducting investigation, we thought that this is enough evidence to arrest someone and initiate investigation and then move to trial. But on the other side, when the investigation happens, it might just be a normal routine transaction. So I think that read is very different. So I don't think it's as beneficial. But yes, rightly said, when the grounds of arrest are documented, it's going to make life easier for the accused and for the lawyers to get bail, because then a defense can be prepared in that direction. Even if there is a requirement of twin condition of bail under section 45 and that stays, there are more chances that we can fulfill those twin conditions by explaining the court that what grounds, on the grounds on which the accused has been arrested, are incorrect, and the person is not actually, has not committed that particular crime. But till the time we don't even know the grounds what I'm going to challenge when I file for the bail application. And that's why we've seen such a mess in the whole in the whole structure of getting bail in PMLA matters.
So now moving ahead with the issue of case diary, the absence of case diary uh, in PMLA proceedings. Now, the case diary, as mandated under Section 172 of CRPC, maintains a chronological record of the investigation process conducted by the police officer. Now, this detailed documentation includes every step taken during the investigation, such as date and time of receiving information about the crime, the start and finish times of the investigations, location visited, etc. Now, in PMLA cases, one key issue that often arises is the absence of case diary. Now, what are the implications of not having a proper case diary in such investigations, and how do you think we can make the investigation process more transparent and more accountable?
Yes. So I think let's talk about the basics first here. I think the absence of case diary in PMLA cases definitely raises significant concerns about transparency, accountability, and fairness. In the way the investigation has been conducted. A case diary typically, as you have mentioned, records all the steps which the enforcement agency has taken, what evidence, how many statements have been recorded, what has happened on daily basis, blah blah blah, gets recorded. Now, the implications of not having a case diary are wide. First of all, again, lack of judicial scrutiny. n- the judges don't know exactly what the enforcement agencies are doing, and that is again the big problem here, because they are not the enforcement agencies can't be held accountable for anything which is not recorded. And again, coming to my first, the initial statements which I made, that any statement which is being recorded by enforcement directorate when a person is called and is summoned under sections 50, the statement gets recorded. Now, for example, one accused gets 5 statements recorded. There is no accountability on the accountability to see how many statements have been recorded. ED can pick up whatever suits the best to the case and put it on your charge sheet and can submit it to the the- now the judge does not know the background about that story, but whatever story which was built up with the questions being asked by the enforcement directorate is very comfortably picked up to suit the matter. Even any statement which is given by them for any other person is admissible. So this is a big concern. And again, you see, Prakhar, the concern starts step by step. When you don't see, CRPC procedure was drafted with a vision that yes, there should be a fair process of doing any kind of investigation, or like the fair process should be there. But you completely, when you remove that, everything crumbles down. Now again, like when you don't have case diary, a lot of implications happen with one step. Not providing ECR, a lot of implications happen.
Hmm.
Now another thing which is which I was talking about, and as we this is like this is an observation which I'll tell you. Vijay Madanlal case mentioned that the case diary is not required, and then no one has talked about case diary, and they have said that enforcement directorate is not required to maintain a case diary. But however, if you read PMLA carefully, it is mentioned that PMLA also has to is also the process has to be conducted in accordance of CRPC. So the problem is, if it has to be in accordance with CRPC, then why case diary is not there? And I'll tell you from my experience, enforcement directorate has a diary, but the problem is that nothing gets recorded into that after the Vijay Madanlal Chaudhary's matter. And another problem is that the ED case diary is not paginated, wherein in other case diaries you have all the numbering there, so you cannot remove any pages. Even if the case diary is being maintained, and if the court says okay, maintain the case diary in this matter, the enforcement director officers can remove whatever the pages they want to remove. It's like a normal file. So these are the main issues which I think need to be resolved. uh, at bare minimum, a case diary in ECIR should be something which should be relooked into, so that again, like we have some kind of like we can bring some kind of like defense mechanism for the accused.
Okay. So just a concluding question now. With the Supreme Court set to review the Vijay Madanlal case, what are the key changes or outcomes we might anticipate? In your opinion, what should this review ideally address to balance scales between effective law enforcement and safeguarding individual rights?
So I think, Prakhar, I would say at the bare minimum, uh, the the court should really consider making ECIR available to the accused. I think that's going to make a big difference. And second thing, I think small requirements such as maintaining of case diary, steps to be taken into that directions are very important. Something which we noticed from the Prem Prakash judgment about admissibility of a statement which is recorded in another matter in which you were arrested by the same agency cannot be used by the same agency in a different matter. I think there should be some process laid down on this, because the admissibility of a statement is also a big concern. Because when you have lack of transparency, you really don't know how the investigation has happened. If you were coerced, what happened in the investigation room? Were you pressurized or not? Were you given any kind of like bait that, okay, if you tell us this information and we are going to let you go? So I think these are the key concerns and the principles, and again, in accordance with the fundamental rights, should be looked upon very carefully. And we should, I hope, that there is some kind of positive news coming out from that review.
Thank you, sir. Thank you very much. As we conclude this insightful discussion, I want to extend my sincere thanks to Mr. Guneet for sharing his expertise on such a complex and critical area of law. Your perspectives on contemporary issues related to PMLA have been truly enlightening. To our listeners, thank you for tuning into this episode of 154 and Defense.
Thank you, Praga. Thank you so much. It was a pleasure to be interacting with you, and look forward to more such interactions. Thank you.
Definitely, definitely.